Our client, a police constable, convicted illegally by Kibera Court on flimsy grounds that he was using an exhibit vehicle for his personal use. Yet, the mere constable is not the custodian of exhibit vehicles. They are in control of the base commander or the OCS. But he was convicted and sentenced. We appealed to the High Court, and before the Justice Grace Nsioka, a landmark departure from other judgments has approved. One, that he will go back to his position as a police officer. Two, he will be entitled for the arrears of all the monies that he has never received since 2014. Third, other officers who have been promoted from 2014 who are in his rank, he has never gone for training, he has never been promoted, he has never moved up until today when the court has pronounced itself. And the court has said now he'll go back. His core constables are now chief inspectors. So we will be moving for the implementation of that judgment so that he moves from the rank of a constable to the rank of the chief inspector, because that is where the ranks of his colleagues are. The import of this judgment is that it clears the inequality where civil servants, once they are charged, they do not enjoy other benefits other than they have salary. They don't go for training, they don't go for promotional courses, they don't go for promotional interviews, they remain static. Since 2014, he has been a constable, and that is what we are saying. It dramatically alters the concept of interdiction in the public service. That once you are interdicted, it does not mean that you lose other benefits, because you are still innocent until convicted and until all avenues of appeal have been closed. So we are very happy with the judge that now our client will go back, and very many police officers and very many civil servants facing the same fate. The solution has now been that at the time you were interdicted, at the time you were charged, you are entitled to the benefits of the others, because it is discriminatory to remove one from the chain of promotions just because he is interdicted and is either on half pay or not half pay. So we are happy with the judge, and we hope that that settles that question, which has been always a question that once you go back, you lose promotional opportunities, you lose other benefits of training. Now he will be promoted, and we hope if the police will not implement that, we shall be moving to court to cite them for contempt, and out of that, we are very sure that they will implement that. Any questions from the media?
Who is a police constable, was charged in the year 2014 with the offense of converting to his own use a motor vehicle that did not belong to him. He was charged alongside his fellow constable, and when the matter was decided in the trial court, he was convicted while his colleague was acquitted. Now he moved the Court of Appeal, and he moved the High Court, and the judgment was delivered today. Now, in the judgment, the court highlighted, Honorable Nzioka highlighted, that the burden of proof lies with the prosecution for them to actually establish and determine that, number one, there was the existence of the said motor vehicle, that the appellant was using the motor vehicle without permission on the dates as articulated in the particulars of the charge sheet, and that whatever he did amounted to an unlawful use. Now, the court found it that the prosecution gave insufficient evidence. They adduced insufficient evidence because not any of the prosecution counsels who came to court evidenced or gave their testimony that they saw the motor vehicle being driven by the appellant, who is our client here. Now, one other thing that stood out is that even the supposed owner of the motor vehicle, who is supposedly supposed to be dead because the car was gotten from a robbery with violence offense, did not come to testify in court. So the court relied on the evidence that was adduced by the Chief Inspector Police, who said that he was compromised, or he was influenced by the appellant to give him the car, to give him the car keys where he would ignite the said motor vehicle on a daily basis. The court also noted that there were disciplinary proceedings, and this particular chief inspector was not, his evidence was not compelling to the court. And more so, that the appellant hearing, if indeed, because he was a constable and the chief inspector has that of a higher rank, it is not believable that a constable would influence the decisions and the findings or any action by someone who's senior in his rank. Therefore, that did not hold water in the High Court, and as such, our client was the sentence he was given was set aside. Now, one other thing the court noted is that in the event that the DPP was very particular in ascertaining the reason as to why the whereabouts of the motor vehicle and the charge, then the constable ought to have been charged alongside the chief inspector, because there is no way he, as our client, would have authority over someone who has a higher hierarchy than him. So overall, since the year 2014, our client has not been able to enjoy his salary in full, and now that he's a free man, we are hopeful that he's going to be reinstated. And even the court was keen to highlight that in this, as the situation is, that particular chief inspector has now since been promoted to a higher rank. Then also our client here ought to be promoted in the same spirit. So we are very happy about that judgment, and now I leave the floor to my senior.
Songa katikati mwake.